Now, in law, what's happened in 1990 or 2003? No, 1993. I'm sorry. In 1993, the bar changed their oath to the bar. Okay? Prior to that, lawyers had to be respectful to the crown. And by prior to that, I mean 1559. Let's go back. From 1538, when King Henry separated from the Pope, to 1559, everyone swore to the king as supreme, and the king was above the law. So all lawyers and all subjects had to submit to the king because he was above the law. Okay, the laws were there for you to be governed under them, but he could break the law. Okay, with Queen Elizabeth in 1559, lawyers were respectful to the crown. Okay, because the queen, the law applied to the queen herself.
Oh, so there are more.
The law, no one is above the law.
Peers,
basically. Yeah, no one is above the law. That's where in 1559 that happened. Okay, and that's when they became God is supreme. Okay, and the queen is under God. Okay, the queen is not God. Under King Henry VIII, the king is God. Okay, now in 1993,
the queen is just basically an extremely influential subject.
Fine.
From
now,
that.
in 1990, let's back up a year. In 1992, Canada signed and ratified the last final lines of NAFTA. In 1993, the bar went behind closed doors, and they now, all lawyers since 1993, they're no longer respectful to the crown. They are submissive to the crown. So they've gone back to King Henry VIII's archetypal form.
Yeah.
Okay, and that's a deep. Okay, and in law, they've done it many, many times. When the form is broken, which is the system, the form, the archetypal form is broken, it's traditional how to fix it is fall back a form. And that's what they did. They went back to the period of 1538 to 1559, when the king was supreme. And right now, 20 years after they did this, civil servants and lawyers swear their allegiance to the queen. They no longer swear to God, they swear to the queen. Okay, and that's a really distinction. And that means all lawyers, all politicians, everyone is submissive to the crown who can break the law. We've gone back to that. But the crown is now called Parliament. And it's a body of people who are above the law. And, if you go, I've got this beautiful article I did on Section 1 of the Charter, outlining on one of my recent, go to my Facebook or my website. Right there at the beginning, I'm outlining Section 1 of the Charter, how it's misread and abused by what's called lexicography, which is an addiction. In Black's 7th dictionary that introduced 7,000 new words and phrases to the law dictionaries, says in its preface that this was done to have a greater understanding of Roman and especially feudal law. And what that means is the law adopted all the slavery terms that were taken out of the law with the American Constitution and the slavery of Lincoln. All those slavery terms, what are called colorful terms in law, returned into the lexicon of law. And I'm saying that was done by the works of a man called Archibald Cox, which you can get a great lawyer, who wrote the civil disobedience.
That's crazy shit, man.
Civil disobedience and the Constitution and the law. He wrote this. He wrote this in 1968, just before impeaching Nixon. Okay, and it was all about Martin Luther King and John F. Kennedy and the peace movement and the anti-war movement, showing how valid it was. And it's all the case law precedences, and it shows in really deep. I read that article once a year because it's so deep, and the guy's giving one message, and there's a whole message behind it, where he's saying that he's authorizing authority with all these case law precedents of Wallace against the march in Lafayette, the case law of this, to say that authority, the best thing authority could do is be in civil disobedience of the Constitution in order to effect radical change in society. It's the smoking gun of there's actually guys really high up who are good people who did evil for good reasons. It's the best argument the system's ever had, and it's this work done by Archibald Cox, and I've listed it many times on my website.